When considering the process of amending the company charter for a single-member limited liability company, LLC, where an organization is the sole owner, it is important to follow both the legal framework and internal policies as stipulated in the relevant laws. According to Vietnam's Law on Enterprises 2020, such companies may be organized under one of two management models. Model 1, comprising a chairman and general director, or Model 2, comprising a members' council and general director or director. Each model has a slightly different process for organizing meetings and approving amendments to the company charter. For companies operating under Model 1, where the structure includes a chairman and a general director or director, the process is streamlined. There are generally no legal requirements regarding quorum or specific conditions for convening such a meeting. The content of the meeting will focus exclusively on the proposed amendments or supplements to the charter. The responsibility for this process primarily lies with the chairman, who is appointed by the owner organization and acts on the owner's behalf. First, a draft of the proposed amendments is prepared. The chairman then receives the official decision from the owner regarding the proposed amendments. If needed, the chairman may convene a meeting with relevant specialists to review and refine the draft amendments. Based on the owner's decision or authorization, the chairman formally signs and promulgates the amended charter, ensuring that an official copy is stored at the company's head office, as per legal requirements. Finally, the chairman issues an official decision on the amendments, and the amended charter becomes effective. For companies operating under Model 2, which includes a members' council, the procedure is more structured to reflect the council's collective decision-making authority. A meeting of the members' council can proceed only when at least 2/3 of all members are present. Each member typically has one equally weighted vote, unless otherwise specified in the company's charter, and resolutions may also be adopted by written consent. The process begins with a formal notice of the meeting, which can be sent through various communication channels as defined in the charter, such as written invitation, email, or other agreed methods. This notice must specify the time, venue, and agenda of the meeting. All documents related to the meeting, especially those concerning the proposed charter amendments, must be distributed to all council members at least 7 working days before the meeting. The actual rules for distributing other relevant documents may be specified in the company's charter. If a meeting request does not meet the requirements set out by law, the chairman of the members' council must notify the relevant members in writing within 7 working days of receiving the request. In all other cases, the chairman is required to convene the meeting within 15 days of receipt. The meeting itself will discuss the proposed changes, and decisions are made through a formal voting process. The meeting's proceedings must be thoroughly documented in the official minutes, which may also include electronic recordings if the company wishes. These minutes should capture essential details such as time, venue, attendees, voting results, and any dissenting opinions. The signed minutes are kept as official company records, providing legal evidence of the meeting's decisions. After the meeting, once the amendments are approved, they are formalized and signed into effect. If the amendments involve changes to information that has been registered with the Business Registration Authority, such as the company name, business lines, or address, then the company must also complete the required procedures with the Business Registration Office. However, for purely internal changes to the charter, notification to the authorities is not necessary unless otherwise stipulated by law. In summary, the process for amending the charter of a single-member LLC owned by an organization depends largely on the management structure chosen. Companies should carefully review their charter to ensure compliance with both the law and internal company regulations throughout the amendment process.